Coming together is the beginning, keeping together is progress, working together is success. Henry Ford. A warm greeting to everyone. On behalf of the PG and Research Department of Commerce at the Raj College for Women, I take immense pleasure in welcoming everyone to this lecture on corporate structure and corporate social responsibility. I now call upon Ms. Gayatri, Treasurer, Self-Supporting Comet Team 2022, to welcome and introduce our speaker to the audience.
A very pleasant evening to one and all. We warmly welcome you to this lecture on corporate structure and corporate social responsibility. Our speaker for today's session is Ms. Smriti, Advocate, High Court. Ms. Smriti graduated with BA/BL degree from School of Excellence in Law, Chennai. She has completed LLM in Crimes and Torts, postgraduate diplomas in Intellectual Property Law, Criminology and Forensic Science, Alternate Dispute Resolution, medico-legal law, and diploma in cyber law. Ms. Smriti is a member of the Bar Association and enrolled as an advocate under the Bar Council of Tamil Nadu and Pondicherry. She has been practicing in Honorable Madras High Court for 13 years now in both civil and criminal practice areas. She is a partner in Veda Law Firm. Ms. Smriti is a legal advisor for many builders in Tamil Nadu. She gives legal opinions on property transactions, joint venture agreements, structuring of commercial transactions, formation of companies, commercial contracts, and international contracts. Ms. Smriti also conducts various legal due diligence exercises and provides litigation services such as appearing before quasi judicial authorities, courts for appeal, settlement, writ petitions, advance rulings, and like. She has drafted opinions on various agreements, deeds, and has scrutinized numerous title deeds for title opinions. She handles writ petitions pertaining to service matters, land acquisition, land dispute, corruption, and other general miscellaneous matters. Previously associated with additional central government, she has acquired experience with SARFAESI Act and DRT cases. Ms. Smriti has been admitted as Advocate Commissioner by Honorable Madras High Court for several cases for execution of High Court order. She is a panel advocate in State Bank of India, UCO Bank, Indian Bank, One Cover Company, and Department of Law and Justice in India representing Tamil Nadu. Ms. Smriti holds expertise in real estate regulatory authority. She also handles matters pertaining to consumer laws and regularly assists clients on the same. She has extensive experience in conducting Lok Adalat proceedings and handling matters on behalf of landline operators and financial institutions. Ms. Smriti is a legal member in the legal committees of Central Polytechnic College, Chennai, Ratha Cytadines, Somerset, and Ascot Internationals. We are extremely happy to have you with us, ma'am. Over to Dikshita.
Thank you, Gayatri. I now request our resource person, Ms. Smriti, to take over.
Hi, everyone. First of all, thank you so much for the invite. Now, the topics that we are going to start is about the corporate social responsibility. So, I have the few presentations here. We can start with the presentation now. Yes. So, today's topics we will be covering is corporate social responsibilities, corporate governance. See, corporate governance is a very big chapter. So, the corporate governance, we are going to deal only about corporate governance relating to structure of the board. So, while discussing about the corporate governance relating to the structure of the board, we will be discussing about what is a board and what is the structure of the board. Then the next topic that I will be covering is board of directors. What is board of directors and structure of board of directors? Then the other few topics I would like to cover up are the winding up of company, STK process, national company law tribunals, and what is insolvency and bankruptcy code that is called as IBC. The next slide. Yes. Today we are going to discuss about the corporate social responsibility. What do you think about the corporate social responsibility? It is nothing much about the corporate's responsibility towards the society. So why do we need this CSR programs and what mandates the law to make it a most important thing? So when we look to seriously, the corporates the corporate's responsibility towards the society is corporate social responsibility, and the law mandates it. The Companies Act 2013 has formulated under Section 135 of the Companies Act, which speaks about the corporate social responsibilities rules, and also this Schedule 7 also prescribes the mandatory provisions for the companies to fulfill their CSR programs. This article aims to analyze these provisions and include all the amendments those are required for. So, when we come into the concept of CSR, what is CSR? It is nothing but just a company's take resources in the form of raw materials, human resources, etc., from the society. By performing these tasks of CSR activities, the companies are giving something back to the society. So, on April 2014, India has become the first country to legally mandate the corporate social responsibility. The rules in section 135 of the Indian Companies Act made it mandatory for all the companies for when I say about all the companies, it means companies of certain turnover and profitability to spend about 2% of their average net profit for the past 3 years on the CSR program. So, what is CSR program? The definitions as per the Companies Act, and also it defines, the Companies Act defines, and the Ministry of Corporate Affairs defines. Government of India notified in Section 135 of the Companies Act, along with the company's corporate social responsibility rules in 2014. Moreover, while proposing the corporate social responsibility rules under 135 of the Companies Act, the chairman of the CSR committee mentioned the guiding principles as follows for the common good and demonstration. So, the mandatory CSR provisions were made effective from 1st April of 2014 for the companies with a certain profit turnover. This CSR program is not applicable to all the companies that are registered with ROC. It has certain profit turnovers that has to come under this CSR rules. Next slide, please. Okay. So now here in this slide, I just discussing about this criteria for CSR eligibilities of the companies. So Section 8 companies must also establish a CSR committee. And also, why I specifically mentioned about Section 8 companies is that this is a different form of company when it is compared with other companies. Then also any companies that has a net worth of company of 500 crores or more, a turnover of the company to be 1000 crores or more, or the net profit of the company to be 5 crores or more. However, if a company ceases to meet the above criteria for 3 consecutive financial years, then it is not required to comply with CSR provisions until such time it meets the specified criteria. Next slide, please. Now, when we talk about the corporate social responsibility policies, not only with the main act, the Schedule 7 of 2, according with the Section 135 of the Companies Act, it has mentioned about what are the few types of CSR programs that has to be carried out. So these are the few examples that I have mentioned in this slide, and we will be discussing on this. So the CSR activities, these are the examples which the companies take part. First is eradicating hunger, poverty, malnutrition. Number two is promoting the healthcare. Next is livelihood enhancement projects, promoting gender equality and empowerment of women, old age homes, daycare centers, and other facilities for the senior citizens. Next would be promoting the measures for reducing the inequalities faced by the weaker sections. Next would be the providing proper hospital facilities, medicines, and etc. for the health to reduce child mortality rates. Next would be hospital and dispensary facilities with a focus on proper sanction to fight various health diseases. Next would be the ensuring sustainability and an ecological balances in the environment, safeguarding the animal welfare, flora, fauna, agroforestry, and other natural resources. The next would be enhancement of vocational skills by employment. Next would be national heritage, protection of national heritages, culture works towards the restoration of important buildings and sites. Next, the activity would be promotion and development of traditional Indian arts and handcrafts, or including the measures of welfare of the armed force, war widows, or other dependents. Also, the training programs for the rural, nationally recognized or Olympic sports, etc. Also, the companies would strive to contribute to PM's National Relief Fund or other central government developments of social economic issues with relating to the minorities and weaker section. Next would be the contributing towards the central government's technology incubators. Then the development of slums and rural areas. Next slide. So when we are talking about all these procedures, the Act itself gives fines and penalties for the non-compliance. When we look into the fines and penalties, it says the failure of a company to comply with CSR spending provisions or transferring the unspent amount out of the CSR fund, the company will be punishable with a fine which may increase to 25 lakhs but not less than 50,000. Also, the Act also provides for the punishment of the companies officers who default in the compliance. It states that every such officers of the company will be liable for the punishment. That is, the fine will exceed 5 lakhs but not less than 50,000, even the imprisonment for maximum term of 3 years or with both. So, this is something a serious issue. What happens when any company does not do corporate social responsibilities? So, these are the penalties and other imprisonment for the maximum period of 3 years. These makes the companies to mandate the CSR programs to come. So, so it is one of the must and mandatory regulations that the company which we discussed about particular companies which falls into the ambit has to follow the CSR programs. So this is all about our corporate social responsibility. Again, I would like to conclude this particular topic about is why more importance is given to the CSR to the company. This is big because with the simple terms I have already mentioned, since the company takes the resources in the form of raw materials, human resources from the society, by performing such these tasks, the activities, the companies are giving back something to the society. So I would like to go to the next topic, please. Now, since we discussed about the corporate social responsibilities, now we are going to deal and talk about corporate governance. What is a corporate governance? Why so much importance is given to this particular topic? Corporate governance is a very vast topic. So, when we talk about the corporate governance, it means how the entire corporate structures are being governed. Not only with one particular issue, the entire corporate structure has to be governed with certain rules and regulations. So that rule and regulation is the corporate governance. Since the corporate governance is a very vast topic that has to be covered, the topic which we are going to talk about is corporate governance relating to the structure of the board. Next slide, please. Next slide, please. Can you please move to the next slide? Okay. Yes. When we talk about corporate governance, so the corporate governance is a system of rules, practices, and process by which a firm is directed and controlled. So, it is all about a generic term what it is. So, in general, a governance is a system of rules and practices and processes. It is the structure being governed. When coming back to the corporate governance, so this is a balancing the interest of companies with many stakeholders. Not only with the stakeholders, it has to balance with the company stakeholders as well as the shareholders, the senior management, executive, the customer, suppliers, financiers, the government, and the community. So, when we talk about the corporate governance, it provides the framework for attaining the company's objectives. So, it is practically in every sphere the management from every action plans, internal controls to performance measures and corporate disclosures. The next slide, please. So, in general, the corporate governance is the rules and practices that use to direct and manage a company. So, a company's board of directors is the primary force influencing the corporate governance. So, that is why the board of directors are giving such a power. So, a bad corporate governance can cast doubt on the company's operations. So, when we talk about the corporate governance, it covers all the areas of environmental awareness, ethical behavior, which includes ethical behavior, corporate strategy, compensation, and risk management also. So the basic principles of corporate governance are the main principles are accountability by the board, transparency, fairness, responsibility, and risk management. Next slide, please. Now, every time I use the word board, everywhere we are mentioning about the board. What is a board? Why am I specifically talk about the board? I will discuss subsequently what does the board mean and why I'm insisting on it. So the board of directors has to focus on main areas with respect to the corporate governance. The first by establishing the vision and values, then setting strategy, then delegating the authority and exercising accountability to the shareholders. And the most important is they have to be responsible to relevant stakeholders. Now, when we look into the principles of corporate governance, we just understood what a corporate governance is. So, what are the main principles how the corporate governance has to be? It should be fairness, transparency, risk management, responsibility, and accountability. These are the basic five principles of the corporate governance. So, when I said about the five components, it is nothing much more, it is a very simple formulas. When I talk about the fairness, the board of directors must treat the shareholders, employees, vendors fairly with equal consideration. So, this is the first, foremost important of a corporate governance with respect to the board. So it means the board have the next slide, please. So the board should be fair enough to talk about the share. The next slide, please. About the fairness. So it should treat the shareholders, employees, vendors, communities fairly with equal consideration. So nobody's higher and nobody's down when it is mentioned about. The next slide, please. And then when talking about the transparency, why am I being so specific on the transparency? So I think it would be fine if I could make uh, the slide present. So when we're talking about the fair transparency, the board should provide timely, accurate, and clear information about the financial performances, conflict of interest, and risk to the shareholders and other stakeholders. It is not about only with the shareholders, but also the stakeholders' interest has to be protected. Next, risk management. The board should always be considered about the risk management. What is risk management? The board and the management must determine the risk of all kinds and how best it has to be controlled. And also, they must act on those recommendations to manage them. The most important about the risk management is they must inform all the relevant parties about the existence and status of the risk with respect to the company. Also, the next important governance principle is a responsibility. So here, and when I was talking about the board, how important it is. The board is responsible for the oversight of company matters and the management activities. It must be aware that support and successful ongoing performance of the company. The part of the responsibility is to recruit and hire a good CEO. So it must act in best interest of the company and also about the investors. And then the next most important principle where we need to discuss is accountability. The board must explain the purpose of the company's activities and the result of which it is conducted. And the company's leadership must be accountable for the assessment of the company's capacity, potential, and performance. And the most important, the board should communicate the issues to the shareholders. Next slide, please. So, for a better performance of the governance, the board should function. These I have discussed about few functions that a board should follow. The directors should be totally committed. Next, they should set up their priorities, and they must have courage to look into the when any bad situation occurs or any stock marketing, finance, and moral issues. They have to work, come out with this courage, and also they should not exercise the power for their own. And also, when it is concerned abuse of powers or doing acts which are within the scope but not improper in purpose. The next slide, please. Now, when we were discussing about the board, what is a board? The board is the board of directors. Yes, the board of director. What is a board of director? The board of director refers to a corporate body comprising of group of elected people who represent the interest of the company's stockholders. The board forms it is the topmost layer of the hierarchy and focus that the company's efficiently achieves its goals. So when we talk about the board of directors are the elected panel in a company representing the company's shareholders and they include high level corporate position holders. So, in a simple term, next slide please. In a very simple term, a board of directors is the group of officials who the shareholders of the firm elect. Even the idea behind the board of directors is to have a body that safeguard the shareholders' interest as they are the firm's owners. The next slide, please. Now, what is the relationship between the board of directors and the shareholders? What is the relation? It is a very simple relationship. The board of directors and the shareholders flows from the theory of principal agent relationship. Here are the shareholders are the principals or the owners. So the shareholders are the principals or the owners and board of directors are the agent who ensures the safety of the shareholders' investments. So the board needs to ensure the organizational efficiency and allow profit maximization, which will add the shareholders' wealth. So the board of directors as a governance body also need to work on the best interest of the stakeholders apart from the shareholders. So now I insisted upon stakeholders and the shareholders. The shareholders are the someone who owns the share in a company. The stakeholders are someone who are impact or impacted by a project. For example, the creditors, suppliers, any public groups, they fall under the category of the stakeholders. The next slide, please. So, when I talk about the board of directors, there is a structure of board of directors. So, they in different companies, the different positions or panels are involved. For example, when we look into Amazon's board of directors, it has official positions such as chairman, directors, CFOs, and even the CFOs are segment wise, and CEOs, VPs, etc. The board size is limited by a company specifying the minimum and maximum limit in its articles of association. Next slide, please. So, these are the few general basic structure where the board of directors, the hierarchies. First would be the chairman. A chairman leads the board and thus heads the committee or board meetings. The board votes and elects the chairperson. Usually, the company's CEO is the chairman. The next hierarchy would be the managing directors. There are usually no restrictions on number of directors in a company. For example, in its board, the director panels, Amazon has many directors overlooking distinct segments. A managing director is an individual elected by the company's executive directors to manage, guide, monitor the business functioning. When we're coming back to the executive directors, they are individual takes active participation in the company's management, business operations, sales, and finances. So, being a company's employee and executive director is a part of the board and even gets a salary for the company. The director represents the cause of the company. Next. There are non-executive directors also. The non-executive directors, they do not belong to any organization, but they are the part of the board. So the external directors represent an objective and third person perspective. So there is one category called the external directors. Such directors provide the critical opinions and advices by charging a certain fee. So in addition, they give voice to the stakeholders outside the firm. So there are other designations also in few companies they follow. They are vice presidents, CFOs, treasurer, zonal head, vigilancy, audit chief, etc. There are some designation in the board of directors. Even non-profit and private companies usually appoint board members from amongst the family members and the executives. Next slide, please. So here I have discussed about few important roles the directors, board of directors, they generally take care. So their main responsibility is towards the company stakeholders Then another important board of director function is to hold the annual shareholders meeting. Then the board of directors builds a company's foundation by framing its vision purpose. They are the foundation for a company. Then the board also takes crucial strategic decisions and plans, mainly when it comes to mergers and acquisition. And then it ascertains some compensation for the organization top officials. Next, at the time of crisis management, the most crucial role played by the company's board. When a company is in crisis, the board of directors gives it a shield as it represents the firm and accountable for all its actions. So that is why when we talk the more importance of the board of directors. Okay, please. So there are disqualifications of the board of directors. These are the few disqualifications that the board of directors are in when they are into this reasons. For example, any misconduct, fraud, or any funds of personal gains, failure to maintain the fair corporate accounts, then trading even when the company becomes bankrupt, and executed trading in circumstances, or failure to pay the taxes owned by the company. Next, please. This is a simple chart where I have it given. This is the board of directors. Then audit committee, executive committee, nomination and remuneration, risk management committee. With this, with the nomination and remuneration, there is a CEO, and the CEO, next to the CEO, the business development managing director. So between the CEO and the business development director, there comes this company secretary. So the business development managing director is of two types. One who takes care of the sales and marketing and general management. The other person takes about the administration and finance accounting. So this is all about the board of directors. And next we will be looking into the next topic, winding up of company. So these are the topics that we are covering today. We spoke about the corporate the social responsibilities, then about the structure of board of directors. Now we are jumping to the topic of winding up of a company. What? Why do you think it is the most important? It is not just like that. You do a business and just close it and walk away. That cannot be done. So, this is the most important. When you start a company, you should also understand the procedure to wind up. So, now we are going to discuss about how the company winds up. So, winding up of a company is an entire procedure of breaking about the lawful end to the life of company. So, winding up is divided into two stages. One is winding up, and other one is dissolution. So, winding up and dissolution, you think it might be the same, but practically no. The legal implications are different. So, the basic fundamental difference between them with regard to the legal procedures are involved. Winding up is the first stage. This is the stage, the process whereby assets are realized, liabilities are paid off, surplus distributed among the members. So when we talk about the winding up, it is the first stage. So any surplus is left, then it is given to the members according to their rights. But after the winding up, next comes the dissolution stage. That is the final stage whereby the existence of the company is withdrawn by the law. So, who now, when you start a company, who can do this winding up? So, this winding up is dealt with section 272 of the Act. So, who can make the winding up procedure? One, the company itself, then the contributory or the contributors, or any person specified in A and B, the registrar himself, or any authorized person by the central government on its behalf, or in case falling under B, that is any contributories under 271 by the central government or the state government. So When we talk about the winding up, there are two types of winding up: voluntary winding up and compulsory winding up. When we talk about the voluntary winding up, it simply means winding up can be done voluntarily by the members of the company. The company passes a special resolution and then in a general meeting passes the resolution which requires a company to wind up voluntarily as a result of the expiry of the period of duration or as per the articles of association, whatever the case may be. The company itself can come forward for the winding up. This is called the voluntary winding up of a company. So this is a simple procedure how the company can be wound up. One is convene a board meeting and the notice should be served, then pass the ordinance, then winding up the company shall commence from the date of passing the resolution. So this is the most important thing when the company gets winding up. Next, the meeting of the creditors. Then the meeting of the creditors should be made on the same day or the next day, the passing of the resolution regarding the binding up. Next, within 10 days, the notice appointment of liquidator must be filed with the registrar. Then, these are the time frames that has been provided, mandated by law. Then, within 30 days of the general body meeting for the binding up, the copies to be served. And then, affairs of the company and prepare uh, the list and submit it to the liquidator. Prepare the liquidator's account for the binding up of accounts and get it audited. Then call for the final general meeting of the company. Then a special resolution has to be passed and then copy of the accounts and file the application to the tribunal. And then tribunal shall pass an order dissolving the company. When I talk about the tribunal, mostly it will be the NCL, National Company Law Tribunals. Then the company liquidator is required to file a copy of the order with the registrar. And then once tribunal, the registrar on receiving such copy, the order passed by the tribunal, then it has to be published and a notice of such publications to be made in the official gazette that a company is dissolved. Now, so these are the five grounds that I have taken. The first is a special resolution, and then against if any company has acted against the interest or any fraudulent or unlawful purpose has been initiated or default in filing with the registrar its financial and annual returns, if the tribunal is of the opinion that just and equitable that a company should be bounded up. Now, we saw about the voluntary winding up. Now, there is a procedure for compulsory winding up of a company. So, uh, how it is made? These are the simple steps that has to be followed. First step one, file the petition to the tribunal and tribunal will accept it or reject it. And then when it accepts it, a liquidator will be appointed by the tribunal. And then liquidator is supposed to prepare a draft report for the approval. The next would be it is necessary for the liquidator to forward the copy to the register of companies. And then register of company finds the draft satisfactory, then he approves for the winding up of the company. And the name will be struck from the register of companies. And ROC sends a notice for the publication in the official gazette. Now, when we saw about the binding up of company, this is the one of the most important process, that is STK process, that is voluntary closure or strike off. These are dealt with section 248 to 252 of the Companies Act. So, when a company can apply for the closure, when a company has not commenced its business, when you start a company, it has to be commenced immediately. When you don't commence a business within 1 year of its incorporation, or the company is not carrying out any business or activity for the preceding 2 financial years and has not sought the status of dormant companies under section 455 of the Act, the subscribers to the memorandum have not paid the subscription money and a declaration of this effect has not been filed within 180 days of its incorporation. So 2482 of the Act is the statutory provision. A company may on its own file an application for striking off to the registrar for the removing its name and by passing a special resolution, and that has to be signed by the certified company secretaries or CA or CWA. So when we talk about the closure of companies, voluntary striking off, these are the procedures that has to be followed. One is whole board meeting, next pay off the liabilities, then convene a EGM and pass the special resolution, and then file special resolutions, and then there are few documents SDK2 forms that has to be complied with. And then after receiving the applications, the register of companies shall publish the notice and to seek objections from the public. And then notice shall be placed on the website of the Ministry of Corporate Affairs. Then ROC shall simultaneously intimate the concerned authorities. And then after complying all the process, the ROC shall strike off the name and dissolve the company. When this is done, after complying all the process, the ROC shall strike off the name and dissolve the companies by sending notice in the official gazette. So, so when I say about the winding up and striking up, it is not like just you start a company and suddenly you close the company. So law doesn't permit it. There are restrictions in making the applications also. You cannot just like that start a company and take a lot of money from the bank and just like that close and run away. So the companies to make an application for voluntary striking off, there are restrictions also. So what are the restrictions when these categories, whatever I have mentioned here, comes into then these are the restrictions. One, if it has changed the name and shifted the register office to some other state, then disposed the value of the property for the purpose of disposal for gain in the normal course of trade. Then, if the company has engaged in any other activities except the one which is necessary, or any application to the tribunal, or the company that has been delisted due to non-compliance. When these are come into the picture, these are the restrictions of making the striking ones. So these are also the other provisions when the investigation is ordered or any pending if any case is pending before the court or compliance against any prosecution for the offences or companies whose application is pending, compounding is pending before any competent authority or if the company which has accepted public deposits. This is the most important criteria here. When the company accepted the public deposits, which are either outstanding or the company is in default of the repayment, then these aspects has to be taken care of. Then the companies having charged with the pending for satisfactions. So these are the important aspects that has to be followed. And now we will be looking into the topic. Slide please. Insolvency and bankruptcy code. So IBC, this is a very big topic and needs to be dealt separately. Due to the time constraint, I shall be dealing with the basic and important sectors that we need to discuss. Now, what is insolvency and bankruptcy code? Why such importance is given to this? So, India is a growing economy. There is a healthy credit flow and generation of new capitals are essential. When a company business turns insolvent or sick, it begins to default its loan. So, in order to credit, not to get stuck in the system or not to turn into a bad loans, it is important that banks or the creditors are able to recover as much as possible from the defaulter in a quick way. And this is why the IBC has come. So, the business can either get chance it's still viable to start afresh with new owners, or its assets can be liquidated or sold off in a timely manner. So, this way, fresh credit can be pumped into the system and value the generation of assets can be minimized. So here it is just a very small brief. In 2016, at the time when India's non-performing assets and debt defaulters were piling up, and older loans recovery mechanisms like SURFACE, low-credit, and DRT were seen to be performing badly. The Insolvency and Bankruptcy Code was introduced to overhaul the corporate distress resolution regime in India and consolidated previously available laws to create a time bound mechanism with a creditor in control model as opposed to the debtor in possession system. So, when insolvency is triggered under IBC, there are only two outcomes: resolution or liquidation. When all attempts are made to resolve the insolvency, either coming up with a reconstruction, a new ownership plan, and if resolution attempt fails, then company assets are liquidated. This is the very simple logic. Either you restore the company and that fails, then company's assets has to be liquidated. So what is the process followed under IBC? So now I will be discussing about a very short and the sections that are relevant. I will not be discussing on an elaborate way. So the important sections that has to be taken care. First, when a corporate debtor or a company which has taken loans to run its business defaults in its loan repayment, either the creditor, a bank, or an entity that has lent money for the operational purpose, or the debtor can apply for the initiation of the insolvency resolution process under section 6 of the IBC. Yes. So, for applying the insolvency, one has to approach the National Company Law Tribunal branch. Yes, please. So, once this application is admitted, the adjudicating authority appoints an IRP, interim resolution professional, who will act on behalf of the company. He can be a chartered accountant, secretary, company secretary, or a lawyer. Once the tribunal appoints the IRP will take control of the defaulter's asset and the operations. And it collects the information about the state of the company and finally coordinates with and constitution of the committee of creditors, or they call it as a COC, committee of creditors. So the insolvency profession invites and examines the proposal for the resolution plan and it submits the plans to the COC. If the COC fails to approve the resolution plan, the companies then goes into for liquidation. If the plan is approved, then what happens? The COC summons to the tribunal. So everything is a time bound. So when the COC approves the plan, when the debtor is bound to implement, the adjudicating authority can also reject the plan. So insolvency resolution process, it come as I said earlier, I'm not going to discuss about the entire sections of the act. I will be discussing about the important section, that is section 6, section 7 of the code, which talks about the operational creditors, and section 8, the code against the corporate debtor in the NCLT. Before going into it, who is a corporate financial creditor and who is an operational creditor? Financial creditor is like the financial institutions who has given the debt, for example, banks and other financial institutions. When it comes to operational creditor, who has given goods, service providers, and etc. So, the insolvency proceedings can be made voluntarily also. That is being dealt with Section 10. Then, once the resolution process begins, the entire period is called the moratorium. It is ordered by the NCLT. And the most important thing is no judicial proceedings can be initiated at the time of the moratorium. So the next step is the appointee interim resolution professional under section 16. So, and then I'm just discussing about section 13, that is declaration of moratorium and public announcements. Then section 14 about the cause of public announcements. So section 16 provides the appointment and tenure of the interim resolution professional. So the resolution professional has to work under the guidelines of the Committee of Creditors, which is dealt in Section 21. And Section 22 talks about appointment of the resolution professional. And these resolution professionals can also be the interim resolution professional. Next, when the decision of the COC is binding not only on the debtors but also on all the other creditors also. Different types of revival plans includes the fresh finance, sale of assets, and other accepted by the creditor of the amount lower than what it is due to them, the change of management, etc. The committee should approve the resolution plan forwarded by the creditor. Only upon the approvals, the resolution professional forward the plan to the adjudicating authority. So, a resolution plan has to be approved by the NCLT. While doing so, it has to consider the main objections of the resolution plan by any party interested in voicing such objections. The voicing objections will be mostly of operational creditors, financial creditors, etc. So, the next topic we will be discussing about this. Next slide, please. National Company Law Tribunals. So, what's the so what is an NCLT? It's a National Company Law Tribunal. It is constituted under Section 408 of the Companies Act and the constituted as adjudicating authority for the purpose of insolvency resolution as well as for the liquidation of the corporate persons. So, when I spoke about insolvency, it is a financial distress where the company is unable to pay the debts. Then liquidation is the process when the company's assets are sold and the company ceases to operations it and it's deregistered. So NCLT is regulated by the Companies Act. NCLT is a forum for resolution proceedings concerned like liquidation, insolvency, winding up due to bankruptcy. The following are the conditions precedent to be considered before filing an application before NCLT tribunal. So, an application before the NCLT under Section 7 and 8 of the IBC Code won't be maintainable before tribunal if even there is a slightest doubt or dispute regarding the payability of the amount claimed by the operational creditor or the financial creditor. Even this has been discussed in Annapurna Infrastructure Private Limited versus Solrail Infrastructures Limited. Secondly, if the amount claimed by the creditors are time barred, then the application will not be maintainable before the tribunal. Lastly, the claim for uh, short delivery or non delivery is also not maintainable. Now, admission of insolvency resolution application before NCLT. There are three persons who can initiate the insolvency resolution application before the NCLT. Now, when we look to the three person who can look into to initiate the process are financial creditors, operational creditors, and the corporate itself. Now, who are the financial creditors? So, the section 7 of the IBC particularly speaks about the financial creditors. They can also take IBC proceedings. Then, operational creditors. Operational section 8 of the IBC code talks about the petition filed by the operation creditors. So, and then here I have discussed about the how the operational creditors look into and start the initiation of the proceedings before the NCLT. Then next is the corporate itself can make the proceedings before the NCLT. The next slide, please. These are the basic requirements that NCLT will follow. First, they will scrutinize whether really the existence of default is there. Next slide, please. Admissions by the NCLT. So, when the tribunal is satisfied that there is a default on the application, then the IR, if the tribunal is satisfied and no disciplinary proceedings pending before the proposed IRP will be accepted in the application. Then NCLT can even reject the application, but before rejecting the application, it is mandate for the tribunal to serve a notice to the applicants. Next slide, please. So the NCLT has the powers even to extend the time. But since I mentioned earlier, IBC is a time bound and NCLT is bound with the time. So everything has to be a time bound, but not more than this. So when NCLT is satisfied that the resolution is approved, then moratorium ceases to have an effect and the resolution professional is relieved of his duties and all documents related to IRP are consigned to the board. Whereas the NCLT is not satisfied about it and by an order it rejects the plan and the liquidation process gets started. So, to initiate the liquidation process, the NCLT has the power. Yes. So, these are the few powers that I have discussed about it. The next slide, please. Now, when a dissolution order is made, the liquidator shall make an application to the NCLT for the dissolution of the corporate person. On such an application being filed, the NCLT shall order that the corporate person shall be dissolved from the date of the order. Now, the power in case of malicious and fraudulent proceedings, penalty will be imposed. Then, power in case of the fraudulent or wrongful trading, then the NCLT will pass an order that any person who were party to such business transaction shall be liable to make the contributions to the assets. And also by an order, uh, the NCLT may direct the director or the corporate debtor, as the case may be, shall be liable to make such contribution to the assets of the corporate debtor. So, now I have concluded with the topics that were assigned to me. Hope you would have understood, and any such clarifications are required, we are pleased to welcome it.
Thank you, ma'am, for
Thank you,
enlightening
ma'am.
us on corporate structure and corporate social responsibility. Ma'am, shall we move on to the question and answer session?
Yes,
How do employees get engaged in the CSR work of a company?
it is just a mandate for every employee to get involved. So it is with the management who has to pull the employees into it. And moreover, there is no remuneration for that. The employees cannot ask for any remuneration who gets engaged in it. Yes, please.
Ma'am, what is your opinion about wasting, greenwashing? Sorry.
Hmm. Sorry, can I move? I'll just make about it. It's a greenwashing. Yes. Okay. Can you just give me? I can answer this at a later stage.
Yes, ma'am. Is it necessary for budding and entrepreneurs to concentrate on CSR than the well-established firms?
Is it necessary for the budding entrepreneurs to concentrate on sales? See, as I told you earlier, the CSR, when a company has to involve in a CSR, it has to go into the turnovers. No. So when a budding company comes into that turnover, yes, definitely, yes, it has to concentrate on that.
To what extent do companies contribute their CSR funds to government schemes?
To what extent? Of course, it has to uh, contribute 2%. I hope every company does that.
Thank you. Can the amount spent on COVID-19 relief work be considered as CSR expenditure, ma'am?
Yes,
How should we organize CSR activities to ensure that the strategic goals of companies are realized?
how should we organize CSR activities to ensure that these goals are accomplished? See, as I mentioned, the few set of requirements, no, like the even in the seventh schedule, the list which I have given, eradicating hunger, promoting the preventive health. The when the company looks into all these uh, points which I we have mentioned, all the 16 points, yes, it has to look into it. And the company's management has to organize the activities which falls into that 16-point charter which I mentioned.
Yes, ma'am. How often and how much corporative restructuring is necessary to keep ahead of competitors?
How often and how much corporate restructuring is necessary ahead of the competition? How much corporate restructuring is necessary? See, the company has to play in a faster phase when it comes to a competitors. Every day it has to be get updated, and when a competitor comes in, the product gets more healthier. So I specifically says yes, there should be a competition, and that makes the products more healthy.
Yes, ma'am. Is CSR used as a vital strategy for brand recognition by leading companies?
This is a very tricky question. CSR used as a vital strategy for brand recognition. Yes, that is why when you see a company which goes into CSR, they wear their t-shirts. You can see that all the employees goes with their company t-shirt. That is the brand recognitions. They don't go with the normal dresses or t-shirts. No? Yes.
Are clients of law firms concerned about CSR and their social impact?
Clients of the law firms. Sorry, I didn't get the clients of the law firms concerned about CSR. And it's yes, definitely yes. And the social impact, it see why they are making the social impact. Two things. One, the company Whatever they have taken from the society, they have to replace to the society. That was the main motto of CSR. Yes, they does that. And it is not about the clients of the law firms concerned. Every company which has to go under the CSR, yes, it has to make any social impact over that.
That was the last question, ma'am. Thank you, ma'am, for patiently answering our questions. Now I
Yes.
request Ms. Kavya, editor-aided Comet Team 2022, to propose vote of thanks.
Some are born great, some achieve greatness, and some have greatness thrust upon them. William Shakespeare. On behalf of the PG and Research Department of Commerce, I deem it a great honor and privilege to propose the vote of thanks on this occasion. First and foremost, I extend my heartfelt gratitude to our guest, Ms. Smriti, for accepting our invitation and educating us on the importance of corporate structure and corporate social responsibility. I would like to thank the management headed by Thiruviya Muralidharan, Chairman Dr. D.B. Usharani, Principal and Secretary in charge, and Dr. T. Usha Priya, Vice Principal Self Supporting, for their constant support in all our endeavors. We extend our sincere gratitude to Dr. A.S. Saranya, Head, Department of Commerce Aided, and Ms. Geeta Krishnan, Head, Department of Commerce Self Supporting. Our heartfelt thanks to all the teachers of the Department of Commerce, both aided and self supporting. I would like to take this opportunity to thank my fellow coordinators and members of Team Comet 2022 for the successful conduct of this program. I also thank Ushobana, Assistant Professor, Department of Commerce, Self Supporting, and the technical team for their unparalleled technical support throughout the session. Last but not the least, I thank the audience for their time and cooperation. Participants are requested to answer the feedback form given in the comment section. Thank you all once again.